director of the Center for Social Science Scholarship, which coordinates our biannual Social Sciences Forum lecture series. There's a couple seats spread out throughout, so if you are still looking for a seat, please come on up. There's one couple here up at the front. This is our last Social Sciences Forum lecture of the year, and we're going out with a bang here. But I want to take a brief moment to mention one other important event that is coming up. On Friday morning, we are sponsoring this year's research forum, which is on the topic of immigration and mobility in higher education. We have a wonderful lineup of faculty across the university that will be presenting their research. So please join us in the library upstairs on the 7th floor from 8:30 to 2. You can drop in, so please come as you're able. I'd also like to invite you to engage with us online and on social media. You can check out our website, socialscience.umbc.edu, and follow our My UMBC group. And we're also on Facebook and Twitter at UMBC SocSci. And as you can see, our speaker this afternoon is also an active Twitterer. So if anybody out there is live tweeting, please don't forget to tag her as well. Thanks so much for being here today, and thanks very much to the History Department for organizing this lecture. And I'll go ahead and turn things over to Dr. Michelle Scott.
Good afternoon. I'm Michelle Scott, Associate Professor of History and Affiliate in Gender, Women, and Sexuality Studies and Africana Studies. Welcome to the History Department's annual Lowe Lecture. It wouldn't be right if we didn't give a little bit of history about Dr. Lowe. This lecture is named for Dr. Wilford Augustus Lowe, or Gus as he was universally known to friends and colleagues, who was a professor right after World War II at Maryland State University, or what is now Maryland Eastern Shore, where he taught from 1948 until 1966. He was one of the first African-American historians to write for the OAH, the Organization of American Historians. His seminal study, The Freedmen's Bureau in the Border States, became known throughout the academic world, and it's actually a piece that I've used myself in the 21st century. He became the 4th editor for what was then called the Journal of Negro History, which is now the Journal of African American History, and wrote or co-edited the authoritative text, the Encyclopedia of Black History in 1981. In 1966, Dr. Lowe was a founding member of the History Department here and helped build the History Department. He retired in 1984, and this lecture is annually given in his honor to celebrate scholarship in African American and Southern United States history. I am honored to introduce the Lowe lecturer this afternoon, Dr. Martha S. Jones, who knew me when I was just a lowly undergraduate, just writing those research papers that you guys are researching. Dr. Jones is the Society of Black Alumni, the Black Alumni Presidential Professor and Professor of History at the Johns Hopkins University. She is a legal and cultural historian whose work examines how Black Americans have shaped American democracy. She holds the PhD from Columbia University and the JD from the CUNY School of Law. Prior to her academic career, she was a public interest litigator in New York City, so that shows you can transition your careers at any moment. She is the author of the text that we're going to hear about today, Birthright Citizens, A History of Race and Rights in Antebellum America, and also the author of All Bound Up Together, The Woman Question in African American Public Culture. She is the co-editor of Toward an Intellectual History of Black Women, and will be the editor of the forthcoming work, Vanguard, A History of African American Women's Politics. She's won numerous awards. She is known nationally and internationally, both as a legal scholar and a public historian, working on museum exhibitions like Reframing the Color Line and Proclaiming Emancipation in conjunction with the William Clements Library and in collaboration with the Smithsonian National Portrait Gallery. She's also most recently the winner of the OAH, or the Organization of American Historians, Liberty and Legacy Award for Birthright Citizens, which she was just awarded last week at our annual convention. And you can see her on PBS if you turn on your channel tonight. She's featured in the Skips Gates documentary on Reconstruction. So it's now my honor and privilege to bring to the podium Dr. Martha Jones.
Good afternoon. Thank you to everybody who made it possible for me to be here this afternoon, to give me a chance to talk about many things, including the early history of Black Baltimore with you through this lens, or this question that we will explore this afternoon, that of birthright citizenship. It's an honor to be here to give the Lowe lecture, and I thank my friend and colleague Michelle Scott. You all should know she never was a little undergrad. She was always a pretty formidable force, but we had the great good fortune of crossing paths at the Martin Luther King Papers project at Stanford, where you indeed were an undergrad, and I was getting ready to start graduate school under the auspices of Claiborne Carson and Susan Carson there. And it is a special treat to be reunited with you here. So thank you all very much. I want to tell a story today about what I think is the first chapter in the long history of citizenship and the long history of contests, disputes, puzzles, concerns over who belongs and by what terms. And it turns out that the very first chapter in this ongoing question that challenges our nation until today, the first chapter is one that unfolds before the Civil War. It is a chapter that unfolds in the lives of Black Americans, former slaves in the United States, and has a special place in the history of early Baltimore, where this struggle over national belonging is deeply and keenly felt. I'll start just briefly with monuments. The one on the left perhaps is one you've seen. If you've not seen it yourself, you've seen it in the news back in the summer of 2017. Roger Brooke Taney, the U.S. Supreme Court Justice, the chief, who was notoriously responsible for the decision in the Dred Scott case, that U.S. Supreme Court case that in 1857 declared that no Black American, be they enslaved or free, could be a citizen. But I want to juxtapose it against the monument on the right, which perhaps is not one you know, but if you do, raise your hand, because I'll want to talk with you after the lecture. So on the right is a monument, an artifact from Laurel Cemetery, which was the first private African-American cemetery, non-church cemetery for African-Americans in Baltimore City. Founded in 1852, the story of Laurel is an interesting one. It was dug up in 1958. If you visit the original spot today, it's the site of a strip mall. But I start us here because this marker on the right is a monument, a grave marker for a man named George Hackett. And I want to propose to you this afternoon, I want to proposition to you the notion that Hackett is an important and essential companion to Chief Justice Taney, a man who also spent his life and lived his ideas, if not his ideals, in Baltimore City. Hackett has a monument, as you can see, toppled over and neglected, and at least on some days I think perhaps that's unfortunately apt, which is to say his is a history that has yet to be polished, placed prominently in our collective memory. But I hope I can do a bit of that work with you today. So Hackett is a favorite character of mine, in part because the arc of his life really captures the story of this early chapter of Birthright Citizenship. Hackett is born in 1807 to a free family in Baltimore City. He's born just in that moment in which African American men in Maryland have been disenfranchised by the insertion for the first time of the word white into the state constitution as a qualification for voting rights. So he enters life in Baltimore in a vexed moment where the possibilities, the prospects, certainly the rights of former slaves are constrained and appear to be shrinking. He lives until 1870, through the US Civil War, dying just on the eve of the final ratification of the 15th Amendment that will, in a sense, work to restore the right to vote to African American men in Baltimore and across the country. And so here, Hackett's life story becomes a sort of guide for us through that saga of how African Americans, former slaves, face the constraint, the curtailment, the diminishment of their rights, and how they come to claim them and win them back. If you were George Hackett, a young man in Baltimore City in the 18-teens, where would you look if you wanted to understand who you were before the Constitution? Well, one place to start is constitutions themselves. So I'm going to say a little bit about these texts, because it turns out that these sorts of texts offer too little insight to men like Hackett. The U.S. Constitution is a document that Black Baltimoreans study. They encounter it in the text of newspapers. They debate it in the context of their political conventions. But what they discover when they scrutinize that document is that it doesn't tell us much, if anything, about who is a citizen and who is not. Now, y'all are good students of the Constitution, I know that, so just a refresher. The Constitution draws distinctions between free people, enslaved people, and Indians, but never comments directly on the status of former slaves. The Constitution provides for the privileges and immunities of citizenship, but never tells us who is a citizen and who is not. There's a funny clause in the Constitution that you might remember, and that is that the president must be a natural-born citizen of the United States to be eligible for the office. Well, Black Americans like Hackett seize on that language. It puzzles them, it provokes them, in fact, because what they argue is, well, if the president is a natural-born citizen, there must be such a category, and aren't we natural-born here on U.S. soil? No color line in this Constitution. And this kind of thinking is the beginning of a long, decades-long reflection, study, argumentation linked to the U.S. Constitution, but never contained by it. This is the seed of the claim that Black Americans are birthright citizens. Now, Maryland also has a state constitution adopted in 1776. Remarkably, the word citizen doesn't appear there at all. Are former slaves citizens of the state of Maryland? The Constitution offers no insight. And I offer these two examples to suggest that people like Hackett live in a sort of constitutional or legal limbo. There is a profound degree of uncertainty, but there is also lots of room for maneuvering. And that is the story of birthright citizens. Now, Hackett is not the only Black American preoccupied with this question. And we might ask why. Why citizenship in particular? And the answer is because there are two circumstances, two forces that are bearing down on the lives of former slaves in a city like Baltimore. And Hackett and others like him think that citizenship might be the shield, it might be the protection, it might help them resist these nefarious forces. What are they? The first is a movement we call colonization. Colonization has an old history as a set of ideas back to the 18th century. By the early 19th century, as George is coming of age, colonization is now institutionalized. The American Colonization Society, the Maryland State Colonization Society. Colonizationists are a sort of curious brand of anti-slavery thinkers. That is, colonizationists would concede that slavery in the United States will end. In fact, they anticipate it. Perhaps it will take years, decades, or even a century. But colonizationists are looking ahead to a post-slavery society. And what they all agree upon is this, that the future of the United States is as a white man's country. And in order to ensure that, colonizationists raise funds, lobby in the state legislature, they outfit ships, they develop colonies in West Africa, Liberia and Maryland in Liberia, and they work to entice, persuade, cajole, arm twist, but to persuade former slaves that with freedom comes the prospect and the fact of exile away from Baltimore and away from the United States. This is the colonizationist vision for the nation's future. The second force is what we call black laws. Black laws are coming out of Annapolis in the state of Maryland. These are statutes that regulate the everyday facts of life for African Americans. How one can work, what sort of property or goods one can own or sell, how one worships or gathers in public meetings, whether one can own a gun or a dog or travel in and out of the state. In Annapolis, periodically, spates of black laws bear down on men like Hackett, making life uncomfortable, if not untenable. And what men like Hackett understand is that these pressures are intended not simply to regulate everyday life, though they certainly do that. They're intended to make life so untenable for former slaves that they will accept the enticements of colonization and, in essence, self-deport. George will, by the 1820s, marry. He marries the daughter of a family friend. The two fathers at this grand occasion in Baltimore City are both lay leaders, deacons in the African Methodist Episcopal Church in Baltimore. We can find the report in the Baltimore Sun, and it's a grand occasion. George is entrepreneurial in spirit. He begins his economic ambition by running a livery stable. He has a firstborn child, a namesake son named George. But times are hard, and colonization and black laws might be one embodiment of tough times. But in George's own life, his livery stable is washed out in a flood. He loses some of his buildings and some of the horses. His namesake, his infant son, George, passes away. And it is a difficult moment in his family life as well. And George does something that is not uncommon for young African American men in Baltimore City. He goes to sea. He signs up for the crew of the USS Constitution. Who are my Navy buffs? There we go. It's USS Constitution, probably best remembered for its service during the American Revolution. Old Ironsides, as it's nicknamed, is readying for a Pacific tour. And the Commodore, Alexander Claxton, is looking to hire a steward, a body servant, who will attend to his personal needs while the ship is at sea. And George signs on. By 1839, he is shuttling the Commodore's wine and cigars from Baltimore to Norfolk, where the Constitution is being readied. And they will embark on a remarkable journey by any terms, but especially a remarkable journey for a free man of color who has questions about who he is before the law. It turns out that to make a voyage from the perch that is the Commodore's quarters is an extraordinary place from which to watch things unfold. And I'll talk in a minute about what happens there that I think informs George's thinking. But the first thing to know is that this is a voyage that will take George Hackett and the many other men aboard this ship to many ports of call in the Americas, all of which, like Baltimore, are beginning to roil with the question, who are former slaves? What sort of rights do they enjoy? What is the place of free people of color in a post-slavery society? This is the age of emancipation. All right, this is the age of emancipation. And they will visit Veracruz in Mexico, Havana in Cuba, Rio de Janeiro in Brazil, come around the Horn and up the west coast of South America. And in each port city, this is the question that is very much animating life. Now, I mentioned that George is in the Commodore's quarters. And what that means is when you get to port, you actually don't get to disembark. Because when you're in port, it's the time to receive dignitaries, local dignitaries, as well as diplomatic officials. So George is present for some of these rather high-level wranglings, but he's left to rely upon other sailors to tell him what port life is like and how free men of color stand there. But what George is able to see up close is the sort of, we'll say, the sort of trouble that sailors get into when they find themselves with 24 or 48 hours in port. I don't need to say more, I don't think. But it's important to us because it's the beginning of George's legal education. Because out of the Commodore's quarters are those proceedings, some of them informal, many of them formal courts martial. This is a place in which, on a naval flotilla, we now see the convening of a courtroom. And there are two things, I think, that are important in George's observations. The first is that in the Navy, free men of color, black sailors, can testify when charges are brought against their white counterparts, something that would be forbidden in the courts of Baltimore City. The black laws ensured that free men of color could not testify against the interests of whites in Baltimore. So we see this inversion. The second piece is with respect to punishment. And what George observes is that when white sailors are found guilty of an offense, they can be punished, they will be punished, many of them by the lash. Here again in Baltimore, by the 1830s, only men of color are still subject to the lash. But in the Navy, the equation of race and rights and justice is just different enough that we can imagine George taking note. Now, the last piece goes back to this sort of puzzle that the constitutions leave us with. Because free men of color, but indeed all sailors, in this period when they set out from U.S. ports. Before they leave, stop at the customs house. Why? Because they want to carry with them what's called a Seaman's Protection Certificate. And these are certificates issued by federal customs officials that testify to, that are intended to serve as evidence of the citizenship of U.S. sailors. They need these certificates in order to resist forced impressment or service into foreign navies. And Hackett and other black sailors like him aboard the Constitution would have carried such a certificate in his pocket in case of the threat of impressment. But it is a federally issued document, is it not, that evidences that he is a citizen of the United States. At the same time, southern ports, most notoriously in Charleston, have enacted port laws that especially target African American sailors. If you arrive in Norfolk or Charleston in this period and you're a free sailor of color, you will not be permitted to disembark. State law will require that you either remain on board or, should you disembark, be detained in a local jail until it is time for your ship to sail out of port. This is a question, or poses a question for U.S. attorneys general and courts. Isn't this a violation of the citizenship rights of free men of color? Well, it depends on whether or not you think they are citizens. And in this period, Chief Justice William Wirt and later Roger Brooke Taney both will tepidly but decisively conclude that free men of color, despite those certificates, are not citizens of the United States, and hence can indeed be subject to these state laws that constrict them in the ports. And this is the world that George inhabits. This ambiguity, these contradictions, this incapacity, it seems, of officialdom to discern not only him, he certainly is discerned as a free man of color in officialdom, but to be discerned and to have his status set, fixed, predictable, consistent. This is not his fate. The Commodore will die of dysentery, fatefully. George will hop a whaler, the Anne, on the Pacific coast of South America and make his way back to the U.S. They disembark in Nantucket, which is the Anne's home port, 2 weeks after Frederick Douglass, another black Baltimorean, has given his very first public anti-slavery speech in Nantucket. George steps off the Anne and into the heart, right, the soul of radical abolitionism, a world in which free men of color can imagine for themselves and in fact embrace something very much like citizenship. And then he does the thing that endears me to him always, which is, by what means we don't know, but over the coming months, he makes his way home back to Baltimore City, and there he will remain. We could speculate about why he comes back to Baltimore. There is family, there is community, there are the institutions that have raised him up, but there certainly are also profound challenges that have only heightened in the years that he's been away. And I find George in an interesting place when he resurfaces in the archives of Baltimore City, and it is here in the city courthouse. And I hope you'll hear in what he does how a man without access, without the sort of context that someone like Douglass will enjoy in New England or New York, how a man constrained by black laws and a very active colonization movement, and the threat that should he speak too loudly about rights, he might be charged with a sort of sedition, how he goes about building the case, that he is in fact a rights-bearing person. The first time I find him, he's gotten into a sort of dust-up on the streets of Baltimore. He says he's been assaulted by a white man named John Pitt. And he does the thing that I think, at least for me, was unexpected. He takes himself over to this courthouse. He visits a clerk. He files a complaint. He attends the trial, and he testifies against Pitt. And he wins. And he goes home with $1 in his pocket for his trouble. But I hope you hear how even in this small episode, Hackett is pushing on and testing the limits of black laws that say he can't testify against the interests of whites. Turns out sometimes he can, or he will be permitted to do so. And that is his story. Hackett, by the 1840s, has inherited his father's role in the local AME church. He now himself is a deacon, church leader, and we find him again repeatedly in the local courthouse, protecting the property, this communal property that are the church edifices and the lots that are the essential structures of religious life for black Baltimoreans. The AME church is set upon by predatory lenders, by real estate speculators, others who look to take advantage of the always fragile fiscal circumstances of black Baltimoreans. And we find George again and again, increasingly in sophisticated ways, fending off the interests of those who would take advantage and hope to undo his church community. He has a robust sense of belonging and of place and of how property figures in to this essential matter in his life. Now, lawmakers have not completely lost sight of men like George, and in 1850-51, Maryland will convene a state constitutional convention, only the second grand constitutional convention in Maryland's history. It lasts nearly 18 months, and quite every learned, influential, highly placed lawmaker, a legal thinker, is a part of these deliberations. They've got many questions. One of them is this question: who are men like Hackett before the law in the state of Maryland? And very forthrightly at the beginning of these conventions, we see delegates putting on the table and insisting that the convention answer these questions. They do a lot of debating. It is learned, it is probing, it is thoughtful, it is concerned. The delegates are so at odds, so unable to come to consensus, they create a committee. And they say to the committee, you all take this question. Who are free people of color before, who should they be as we write a new constitution? Should they be citizens? Should they be denizens? Should they be free people? What sort of rights should they have? The committee comes back with elaborate recommendations. And in the end, the convention fails. They fail to enact any provisions that would resolve or set or fix or define the status of free people of color. They insert a very tepid line that merely affirms that the legislature could answer that question if it would like, because the convention will not. And I like to call this a punt, right? That's a good sport metaphor. They can't score, they can't get to the goal. And so they punt the question to the state legislature, perpetuating, right, this kind of incertitude that is very much a part of George's life. I find him one more time importantly in the wake of this convention in the courthouse, and it is 1859. George has become an entrepreneur, with some success. He's a coal dealer in Baltimore, but by the time he enters the courthouse in 59, his business has failed, as have the businesses of many Baltimoreans, black and white, after the financial crisis of 1857. But for our purposes, part of what's fascinating about his insolvency petition is that we see the way in which he has also woven himself into a kind of economic citizenship in Baltimore City, because in order to have his debts forgiven, he must tell us first everyone to whom he owes a sum, as well as everyone who owes him. Turns out he's owed more than is owed to him, but as he tells the court, the debts are no good, they are uncollectible. But again, I tell you this to help you appreciate the way in which he is woven into the economic life of the city. And then, as the bankruptcy proceeding goes forward, there is that thing that he has learned to do, which is to testify against the interests of whites, in this case, white creditors, those men to whom he owes money. Some of them object, nearly accuse him of a fraudulent petition. We have his deposition in which he explains in great detail the circumstances that have led him, unfortunately, to insolvency. But for our purposes, we appreciate the way in which he is really taking full advantage, if you will, of this opening in the courthouse to be someone who can sue and be sued, who can protect his property before the law, even in the face of ambiguity. Two more things. If there's one part of this story that might be familiar, one chapter in the story that might be familiar to some of you, if not most of you, it is 1857 and the U.S. Supreme Court decision in Dred Scott versus Sanford. Chief Justice Taney, a Baltimorean, concludes that no person of African descent, be they enslaved or free, can be a citizen of the United States. Now, for a long time, too long in my view, we've regarded Justice Taney's decision as somehow singular and definitive. But you know, I'm here to tell you that it's not. Why not? Because in 1858, in the case of Hughes versus Jackson, the Maryland High Court, the Court of Appeals, will be presented with the Dred Scott question. Two free men of color, Samuel Jackson and William Hughes, will face off because Hughes has kidnapped Jackson's children and is holding them as slaves. Jackson sues in Dorchester County. He wins, not only custody of his children, but $750 for the loss of their services. Hughes appeals to the Court of Appeals in Annapolis. And when he does, his lawyer makes a sort of curious but important argument for us. His lawyer says, Justices, this case should be dismissed because Samuel Jackson is a free man of color. And we all know what Justice Taney said about free men of color in the federal courts. They have no rights that white men are bound to respect. In fact, they have no standing. They have no capacity to sue in federal courts. They are disqualified. And Hughes's lawyer says this should be the rule in Maryland as well. Why shouldn't it be the rule in Maryland? Meaning, oddly, but this is the way lawyers argue. I tell you, this is the way lawyers argue. Oddly, that Hughes, too, right, would never be able to sue in the state courts, but that $750 is calling him enough that his lawyer makes the argument that the Maryland Court of Appeals should adopt the cultural logic of Dred Scott, which is one that takes us back to the colonizationist vision, right, which is you cannot extend rights to free people of color because if you do, they might be able to defend against black laws and the force of colonization. Now, it's important to say that Chief Justice LeGrand in Annapolis is not a racial egalitarian. He is not a budding radical Republican just waiting to be unleashed when the time is right. He doesn't have a particularly sympathetic ear for Jackson or Hackett or men like them. However, what he says are two things that are important for us. He says free men of color must have the capacity to sue and be sued in our courts. Why? Because there are 90,000 free people of color in the state of Maryland, and they are workers. They are engines of our prosperity. And what man would work if he doesn't have the ability to protect his wages and the fruits of his wages? We cannot expect free people of color to work if they don't have the right to protect their property and their persons in our courts. It's one. Two, that 90,000 number, right? Legrand says, if I, in one grand gesture, bar free people of color from our courthouses, I will, in that gesture, to create 90,000 outlaws in the state of Maryland. People who will certainly have disputes of all sorts, and now will look to settle them in the streets, in the alleys, in the byways, in the highways, not in the courthouse. So this capacity to come in the courthouse is an essential dimension of social control for someone like Legrand. And indeed, Samuel Jackson will prevail. He will win $750, which just covers his fees to his lawyers, but he will not regain custody of his children until after the Civil War. But you see how a man like Hackett continues to live in a legal and constitutional limbo. Last chapter. Hackett has been doing this kind of work, and men like him have been doing this kind of work of piecemeal, case by case, building an arsenal of rights until 1859, when Curtis Jacobs, who had headed that committee that convened during the Constitutional Convention in the 1850s, Jacobs proposes a new and extreme set of black laws. He proposes that in Annapolis, the legislature provide for free people of color and their status before the law, and they have two options in Jacobs's proposal. The first is re-enslavement. It's a misnomer, right? Most of them have never been enslaved. Nonetheless, Jacobs says you have two choices in this vision. Either you submit to being enslaved, you look out among your white neighbors, you choose an owner, and you enslave yourself, or you will be banished, right? Not by coercion, not by enticement, but by force from the state of Maryland. And when Hackett gets word of this proposal, he acts. First, he circulates a petition in the city of Baltimore, collecting signatures from Baltimoreans, black and white, who are opposed to the legislation. And then he heads himself personally to Annapolis, now to petition his government. Sometimes we call that lobbying. But to petition his government and defeat this legislation. It's an extraordinary moment when he appears in the door, right, of the House of Delegates. It's probably the first person of color to do so who wasn't there in some sort of domestic purpose, serving the delegates themselves. He confronts Jacobs. One story goes, they take it outside and get into a row on the lawn of the State House. Now, if you know the lawn of the State House, it's sort of that sloping, it sounds comical to me, but it's possible. But we do know that they have a verbal confrontation, and in fact, they debate one another over this question. And Hackett now says to Jacobs, I'm here on behalf of that 90,000, right? I represent that 90,000. And my position is that these proposals, re-enslavement or banishment, are a violation of our rights as birthright citizens, rights guaranteed to us by the Constitution, the privileges and immunities of citizenship, prohibit you from legislating us either into slavery or into exile. And he wins. He wins. Maryland lawmakers will defeat this legislation. Jacobs will never again have an opportunity. We know, even as they don't, we are at the eve of civil war and the transformation of this entire landscape. By 1862, Lincoln's Attorney General, Edward Bates, will issue an opinion that affirms that free men of color like Hackett are citizens of the United States. 1866, that year's Civil Rights Act will provide that all persons born in the United States are citizens of the United States. 1868, the 14th Amendment will be ratified and constitutionalize that birthright principle that Hackett had long lived pursuant to, even as others denied it. You can imagine Hackett sort of delighted, right, that Washington had caught up to the argument that he and others like him had long made, were finally acknowledging the sorts of rights that he had been cobbling together and eking out in the local courthouse. George won't live quite long enough to see the 15th Amendment ratified. But what we do know is that in the months and the years after Maryland abolishes slavery in November of 1864, he will continue to be living the embodiment of citizenship. He will join the Republican Party and be among the foremost advocates for the right of African American men to vote in Maryland. He will be a lobbyist, complaining that Black Americans have long paid taxes but have not had access to the public schools in Baltimore City. He will head a local militia, the Butler Guard, and assemble in formation on the city streets, bearing guns, wearing uniforms, and enacting citizenship long before the 14th Amendment is ratified. I think this, for Hackett, was the true embodiment, had always been the true embodiment of citizenship. And the Civil War and Reconstruction, of course, give him a new opportunity. This is the, just months after his death, the celebration of the 15th Amendment will happen. The national celebration is convened in Baltimore City, not in Washington. And this is the plaza, and you can see the battle monument in front of the very courthouse where Hackett had for all those years been waging his own kind of campaign. You have to think, as I do, I certainly do, that he's here in spirit and feeling very much affirmed in his long quest by seeing this extraordinary moment celebrated in Baltimore City. So with that, I'm going to say thank you very much, and I look forward to questions and comments. And I know some folks have to head out, but I'd be happy to take questions or comments, or I have a hand in the back. Would you mind just...
Were free blacks before the Civil War able to own land?
So the question was, can free African Americans own land? The answer is yes, in Maryland and in Baltimore City. But one of the points of contention, right, is whether, for example, should they be exiled? The proposal in the Jacobs bill, for example, is should they be exiled, that they lose their property. They will forfeit their property as well. So yes. And the AME Church is a great example of that kind of collective land ownership, right? You own the lot as well as the edifice, and this is one of the central struggles in Hackett's life. Thanks for that. Hi.
Can you talk a little bit about the research process and how you found all of these archival materials?
I'd love to talk about the research all day. So thank you for that. This book was largely written out of the Maryland State Archives, and where the papers for the Baltimore City Courts are held and have been preserved, heroically, I should say, by the State Archives. So I begin really leafing through docket books and case files, minute books, much of it the work of clerks. These are not records that include dramatic testimony or very lengthy or meaty files. They're really very shard-like materials. But what I'm able to do ultimately is piece together the story of this courthouse, and Hackett comes to me piece by piece by piece by piece in this archive. I'll supplement it by reading the papers of judges and lawyers who are active on this scene at the same time. I will use African American newspapers like Freedom's Journal, the first black published newspaper out of New York in 1827. George's father, Charles, is one of the first agents for Freedom's Journal, distributing it in Baltimore City. Church minutes. But it is true that we don't have a very robust history of legal culture on that level, and so it's a matter of piecing it together. The Constitution story comes out of the National Archives. The Navy keeps wonderful records. So the logbooks, the captain's letters, even some of the Commodore's letters had survived. And in addition to a sailor's memoir that helped me to piece together that bit of the story. So you can see the way in which I'm reaching and ranging in a lot of places over a very long time, I should say. This is not a senior thesis scale project exactly, but it begins like that. It begins like that on one article, one little piece of the archive that helps me be certain I can find people like Hackett and tell their stories. And then I'm launched into a long, many years of research. So thank you. Yes, sir.
I'm curious as to if you have any sense of how the pre-war black laws compared to the post-war black codes. Were they similar in terms of their scope and severity of making regulating every part of life as an African American, or were they different depending on whether you're talking about after the war?
They are different in two important respects. There is not a thread that we would call segregation in the black laws before the war. That is not the preoccupation of lawmakers in Annapolis. So in that sense, they are different. I would say, on balance, they are more severe before the war because the punishments are more severe, right? Infractions of the black laws leave one vulnerable not simply to public flogging or the whip, but to sale as a slave. And so from the Baltimore City courthouse, free men of color are being auctioned when they are found to be in violation of black laws. So I would say, on balance, right, the risk of offense or the consequences of offense are far more. Maybe it's comparing apples and oranges, right? I guess we should be cautious, right? Which is to say, as I hear myself saying that, it is not to in some way suggest that what happens after the war is less severe, but it is different than the laws. But in many ways, we can see in the black laws a set of thought, right? A set of ideas, right? That are adapted to the post-war period and to the particular demands of the demands of white supremacy in the post-war period. So thank you for that. Yeah, hi.
So I don't know a lot about this, but my understanding, if it's correct, is that is there some kind of historiographical debate about Lincoln's role in the colonization movement?
Yeah, I don't think we debate Lincoln and colonization anymore, but it's an important point, right? The colonization is the most popular political movement of the pre-war period. It dwarfs abolitionism, that is for certain, and it transcends parties. And so it is an extraordinarily influential, widely subscribed to movement. Not surprisingly, it includes Lincoln. And Lincoln will hold on to colonization and the vision, the colonization vision, all the way through the preliminary Emancipation Proclamation in the September of 1862. It includes a provision for colonization. It's only in January 1st, 1863, with the Emancipation Proclamation, that Lincoln will largely abandon, at least publicly, colonization. And so that is a reminder to us, I think, of the important degree to which racism and white supremacy, even as slavery will be abolished, persist. There is no abolition of colonization as thought. There is no abolition of racism, even as slavery is clearly going to end. But I don't think we debate it any longer. Maybe some, I think the debate about Lincoln, right, is about whether and the degree to which it's important to us that, so it's a normative question in some sense, which is to say, Lincoln's ideas change over time. How much do they change? How rapidly do they change? How much credit do we allow to Lincoln for the fact that his ideas do change over time? And there are those who rightly ascribe to Lincoln a very important brand of racism for much of his life, and others who more emphasize his evolution over time. Hi.
Thank you so much for this presentation. This has been fabulous. And I wanted to hear you talk a little bit more about how economic contribution and economic power are often the things that citizenship, claims, right, for citizenship are based on, and how it seems to have worked in this scenario in Maryland.
Yeah. One of the ways I think we can think about what Hackett and men like him are doing is that they are comporting themselves like citizens. Right? They are performing citizenship. They are really testing the boundaries, not just in their written word or from a podium in a convention. Right? They are living this. And it's why I think the church is important, and the proliferation of African American, both Methodist and Baptist churches in particular in Baltimore, is important because it is a sign not only of a spiritual community, it is a sign of property ownership, collective property ownership. And there's a moment in the book where I try and map where all the churches are and what it's like to be a worshiper on Sunday morning. And it turns out, if you're a worshiper in any faith in Baltimore City by the 1840s, as you head to and from your own sanctuary, you are going to encounter other worshipers, other faiths, other colors. So there's an extraordinary visibility and a real currency, if I could borrow that metaphor, in Baltimore. So I think that's one way to think about it. But there is a piece that it's still a point of reflection for me, and I say it because maybe someone will hear something in it that I wasn't able to put in the book, that I think there is unwritten but powerful in Baltimore and in Maryland more generally, an exceptional status for free men of color who are property holders. The property ownership is it's subtle and it's not across the board. But that case of Hughes versus Jackson that I mentioned is an interesting one for this, because for many years, people who had studied that case assumed, understandably, that Hughes was a white man and that Jackson was a free man of color. Why? Because in the archival record, only Jackson is marked, as the clerks frequently do, with a parentheses of colored or Negro, black. And Hughes is not. And it takes me a while, right? As I come into the census and I do other things to finally, the light bulb goes off that these are two free men of color who are facing off against each other. Why? My sense, right, is that Hughes is not marked because he's a property owner. He's a farmer and a property holder, and Jackson is a laborer. And we can see this at other moments in the archive, but it is it's just not systematic enough. And the clerks who are so important in this story. I met somebody today who started their career as a stenographer in the Baltimore City Courthouse, and he was telling it like it was a shameful episode. And I said, no, no, no. The stenographer, the scribe, the clerk, I couldn't do this without those folks. But these are not people who, by and large, leave us either guides or manuals to how they work, especially when it comes to race and marking in the courthouse. We can sort of study their practices and recover some of their logics, but it's difficult to make robust claims based on what clerks are doing in the courthouse. It's too idiosyncratic at the end of the day. But when I say this out loud in some rooms, people will say, let me show you this little bit of evidence that I think also suggests that free people of color who are property owners, particularly real property owners, are extended an enhanced set of rights in the courthouse. That a laborer or a propertyless person of color does not enjoy. And this makes some sense to us, doesn't it? Because we appreciate how fundamental property ownership and the logics of property are to our entire constitutional scheme. We appreciate the way in which, part of why lawmakers are straining around this question is that even white lawmakers in a place like Maryland are pretty uncomfortable with the notion that you would, without cause and without process, seize someone's property, because this is, it's because it's nearly sacred, and it opens the door perhaps to other kinds of violations of property rights. So there's a story there that I hope someone, a brilliant young person in the room, will seize on. And I would say these insolvency records are a place to begin because they're absolutely fascinating and really open up a whole story about Baltimore's associational economy and the place of free people of color in it. And I've just scratched the surface, I think, on those materials. So thank you for that.
Any other questions? No? Well, please join me in thanking Professor Jones, and we have a reception. You can come up and ask questions.
Thank you.